Hello everyone, this is Lerone Kuntz. I'm back on my virtual stoop today, and I'm going to read the judge's sentence from the Norman Seabrook trial. Now, some of you might be wondering why he got 58 months. Why didn't he just get 10 months? Or some of you might be saying, why didn't he get 10 years? Depending on where you fall on his innocence or guilt. But the judge breaks it down as to why he's doing what he's doing. So, as promised, I'm going to read that statement, and here it goes. The judge says, "This is the hardest part of a judge's job. We adjudicate cases. We decide who wins and who loses. But in sentencing, we do something that's fundamental. We take away liberty. And the task of telling a person that he loses a certain period of time to pursue liberty is daunting. Furthermore, the criteria for sentencing are not very clear. One criterion contradicts another. The result is that district judges are left with the feeling that he's never quite gotten it right. Either the sentence is too harsh or the sentence is too lenient. But there's never a feeling that you get it right. And perhaps that's a good thing. Perhaps sentencing ought to be tinged with this area of doubt. I'm no better than the defendant being sentenced. I've committed my share of sins, but because it's my job as a district judge to sentence, I have to pass judgment on a person and very often take away his liberty. It turns out in my schedule, I do these on Fridays, so I have this wonderful feeling in synagogue as I listen to the rabbi of thinking about the sentence I just gave out and taking away someone's liberty. But it's a job. I'm not complaining about the job. It is a very good job, but it has this awesome responsibility. Section 3553A of Title 18 tells me the factors to be considered in imposing a sentence. It reads, "The court shall impose a sentence sufficient but not greater than necessary to comply with the purposes set forth in paragraph 2, which I'll get into. Sufficient but not greater than necessary. How do you know what's sufficient? How do you know what's not greater than necessary?" It goes on. "The court, in determining the particular sentence to be imposed, shall consider 1. The nature and circumstances of the offense and the history and characteristics of the defendant." And then paragraph 2, beneath that says, "The need for the sentence imposed, A, to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment for the offense. B, to afford adequate deterrence to criminal conduct. C, to protect the public from further crimes of the defendant. And D, to provide the defendant with needed educational and vocational training, medical care, and other correctional treatment." So it's my job to put all these factors together and find the sentence that is sufficient, but not greater than necessary, to serve all these purposes. The history and characteristics of the defendant, taking into consideration that he has been a strong leader, and perhaps other people have felt that he's not been sufficiently responsive to them. The fact is, he has done major good in his life for the people who trusted their welfare to him. Largely because of Mr. Seabrook, the corrections officers have achieved parity with policemen and firemen. He's devoted his life to them. He was raised in very poor circumstances, and he's risen, and that is something to be looked at with a great deal of approval. Mr. Seabrook comports himself with dignity and inner strength, and that is also something to be considered. But the great mystery that no district judge has ever been able to solve is why people who have done enormous good commit crimes. It's been pointed out by Mr. Bell in his excellent remarks that sometimes people get caught up with themselves. The sin of hubris is ever present to successful people, and Mr. Seabrook has been a successful person. I know he is challenging the jury verdict, which is his right. I know he elected to go to trial, which is his constitutional right. And therefore, I do not count against him that he has not accepted responsibility or expressed contrition. He can't do so consistent with his constitutional right to have the case against him litigated and to appeal. The government has argued that I should take into consideration this absence of contrition. I think I should not because of what I say. So, I have a situation where by nature and characteristics, we should be applauding Mr. Seabrook, but because of the nature and characteristics of the offense, we have to sentence him. Why do good people do bad things? I don't know. Why people should be taken up with themselves and forget about the obligations they serve? I don't know. But where a crime has been committed and the jury has found that a crime has been committed, then it's my job to sentence. The sentence must reflect the seriousness of the offense. Taking a bribe to perform an act that otherwise would not likely be performed is a serious crime. And as the sentencing guidelines point out, where there has been an abuse of trust, it becomes about an even more serious crime. The nature of this crime was to pay Mr. Seabrook a bribe to place a huge chunk of union funds coming to $19 million in a risky hedge fund investment that made its money by so-called leveraged lending, which by its nature means you're lending on assets that are not liquid and that may never receive their hopeful value, in which case loans would be unable to be paid. And since hedge funds work on leverage, it's likely that the hedge fund, if it suffers reverses, they lose everything. And Mr. Seabrook, if we read it, would know it. His lawyers wanted it out. They pointed out the risk. They pointed out that it was impossible for the union negotiators to eliminate the statement of the fund that any investor must consider the possibility of losing his entire investment. And so, Mr. Seabrook committed a serious offense, entrusting not only $14 million of money that was to be kept and preserved for the benefit of pensions and welfare payments, but also $5 million of an operating fund that was necessary to pay bills. Mr. Seabrook, I believe, was blinded by his own sense of his own importance and his desire to benefit himself after benefiting others for so long. So the punishment must reflect the seriousness of the crime. It is to provide just punishment for the offense. That really begs the question. It's necessary to afford adequate deterrence to criminal conduct. There are lots of people in positions of trust. There are lots of people who either don't account or others find it difficult to account. And when they're caught doing crime, they need to be punished because others need to know that if they're caught, they'll be punished. And the punishment has to be sufficiently serious to be sufficient for the crime. I don't think it's necessary to protect the public from further crimes of the defendant. I think Mr. Seabrook has learned his lesson, and I don't think there will be any risk he will be committing any crime in the future. And he doesn't need any educational or vocational training, medical care, or other correctional treatment. So what is a sufficient sentence? Not greater than necessary to comply with the purposes I read out of reflecting the seriousness of the offense, to promote respect for the law, because the powerful can't be allowed to be indifferent to the law, and to provide just punishment. The government argues for 63 months, the top of the guidelines. I don't want to be at the top of the guidelines. I want my punishment to reflect that Mr. Seabrook has been a force of good in life, and I have respect for the excellent advocacy on his behalf. But I want the punishment to be serious to comply with the purposes I mentioned. So, anything between 51 and 63 months. Not that I'm committed to stay within the guidelines. I can go above it, I can go below it. I believe that punishment of 58 months is a just punishment, and I so order it. And that is the statement from the judge. Now, he goes on and talks about restitution of $19 million that Seabrook is on the hook for. He has to pay that money back at some point. They know that he can't pay, and there's other things that are going to be decided later about the amount of money that he's supposed to have. He has three years of supervised release. They talked about that too. But what I read is the judge's sentence. So with that, I hope that this is the last video about the Seabrook case that I'll do. But if not, if there's more stuff, I'll come back and do another video. But until next time, peace and stay safe.
This has been On the Stoop with Lerone Kuntz. Be sure to check out our sponsor, jailkeychains.com, for the best items created to honor correctional officers, because COs are heroes.